toleration of all religions is used to establish supremacy of Hinduism as the only religion that truly respects difference and toleration, since unlike Islam and Christianity, it is not proselytizing religion, though Shuddhi movement and Hare Krishna movement do have such characteristics. According to the logic of extreme right, even secularism is about toleration, and since secularism is about toleration and only Hindus are tolerant, then only Hindus are truly secular. No one else is secular. The principle of protecting minorities, therefore, virtually disappears under the equal toleration of all religions. The various laws through which these minority rights have been protected are attacked as special treatment and as a violation of constitutional mandate of equal treatment. A constitution review committee of BJP many years ago was set up under its vice president, Mr. K.R. Malkani, which had suggested that Article 29 and Article 30 must be deleted. And the poor Malkani did not even see that Article 29 is not a right of a minority. It is a right of a citizen. Article 29 says any section of Indian citizens having the distinct language, script or culture of its own shall have the right to conserve the same. Yes, still they suggested that it should be deleted. It is a vision in which there is no treatment, no toleration, and no protection of religious minorities. Toleration is generally said to require that we accept people and their practices, even when we strongly disagree and disapprove of them. Toleration does not mean that you accept only those things, you tolerate only those things which you like. That is no toleration. Toleration means you accept things which you don't like. But this statement of principle leaves many difficult questions unanswered. What kind of state action does this acceptance require? Does tolerating subgroups involve non-intervention in their affairs? Or does it require a more substantive accommodation of group difference? Minow argues that if toleration simply involves non-intervention in the views and practices of the subgroup, it will fail to adequately respect the subgroup. In her view, the protection of cultural minorities requires more than toleration. Toleration in any case is negative. You tolerate me, you are tolerating, for instance, my speech. I know I am not speaking well. I don't want toleration. I don't want minorities in India to be tolerated. I must be accepted the way I am. Minorities are to be accepted the way they are, without question. That is what the acceptance is all about. It is a call for some kind of internal accountability of democracy that becomes the prerequisite for extending the principle of toleration, and in turn for accommodating a cultural minority's right to do things differently. My marriage is different, my divorce is different, my will is different, my succession is different. I need not have same kind of marriage and same kind of succession and same kind of divorce which others have. I must have a right to do things differently. That is what the secularism is all about. This is my meaning of secularism. Now, coming to Uniform Civil Code, as such, I believe that instead the equal toleration of all religions based on substantive vision of equality should recognize that differences can be accommodated and respected, including those differences with which majority community may disagree or disapprove. Now, on the question of Uniform Civil Code, there was some reference made by Shireen, but I think I need to complete the story. There was some missing gap in the story. Please forgive me, Shireen. She made a mention of Warren Hastings. You see, this allowing personal laws to continue without interference from the state is not the British gift. It is the gift from the Mughals. They did not interfere in the personal laws of Hindus. They allowed them. They only implemented the criminal law. The British continued this tradition. They did not want to hurt the religious sensibilities of the people they were going to rule, and therefore it continued. Therefore, the court system which they established, they were assisted in it by the Pandits if the matter was about Hindu law, and these Pandits were called Judge Pandit. And they were also assisted by the Muftis and the Qazis and the experts of Muslim law. Now, the mistake which Warren Hastings and other British people committed, and which is not generally talked about in the context of entire personal law debate, is this. British come from the common law tradition. Now, in the common law tradition, even though they don't have a law in the written form, this is the essence of common law, they said, well, these people are giving contradictory opinion on a given matter. You know, Shafi'i Mufti and a Maliki Mufti and a Hanafi Mufti, Daya Bhaga Pandit and a Mitakshara Pandit will give different versions. They said we should take it over. How should we take it over? They ordered translation of religious text. And therefore the Dharma Shastras are to be translated. And Hidayah was translated. And in this translation, the real mischief happened. There were mistakes. In fact, originally there were more than one volumes. And then the publisher said it is unwidely for law students to have more than one volume. So the publisher in England on his own deleted some portions and made it one volume which students can easily use. Now the problem with British judges was they thought Hidayah is a statute. They thought Hidayah is an enacted law. They thought Hidayah is like Indian Penal Code or Indian Contract Act. Hidayah is just an opinion. Hidayah is not law, enacted law. They started interpreting this as a statute. Then Islamic law does not know the principle of precedent, that like cases are to be followed. Common law is based on doctrine of precedent. Therefore, they brought in the rigidity in Muslim law by following like decisions. In Islam, each case is a different case. Therefore, if X and Y there is a divorce, there will be one kind of order. B and C have a divorce, there can be another kind of order. But English law is based on doctrine of precedent. Therefore, it was not, my thesis is that neither Muslim law nor Hindu law were as bad as eventually Britishers made them by following the doctrine of precedent. And by bringing in rigidity, by reading Hidayah and Dharma Shastras as the product of legislation. They were not legislations. They are opinions. With those opinions, you may disagree. But remember that they also thought law is not in Quran. They thought law is in Hidayah. Because in Islamic law, lawmaking is a private enterprise. State in Islam does not make law. Lawmaking in Islam is left to jurists. Experts make law. And therefore Hanafis and Shafa'is and Malikis and Hanbalis have made law. This is a private enterprise, just like the Roman law, sir. In Roman law, the state does not make the law. Jurists make the law. So, from day one, I believe, in the Constituent Assembly, we had this problem that the law which they were going to change had become very rigid. Not because it was rigid in itself, but it was made rigid by the British judges. I have counted, for instance, even about the Istri Dhan. Even Manu Smriti talks about as many as 7-8 types of Istri Dhan. But since in Britain, women could not be the full owner of property, the British judges invented the concept of life estate. So they damaged both Hindu law as well as Muslim law. Now, Shireen made a reference to the whole question of gender, but it is strange, and she said it, but it is very strange that in the Constituent Assembly, the question of uniform civil code was not raised in the context of gender justice. It was raised in the context of national unity. And our judges also continue to have same kind of feeling. In the Sarla Mudgal case, for instance, where Justice Kuldeep Singh is talking of uniform civil code and again bringing that same binary to which Shireen was making a reference, that one community has become nationalist, sacrificed their law, the other community is resisting. Therefore, this whole concept of good Hindu, good Muslim, bad Muslim is causing problem. What were the facts? Who were the people who had come to the court? These were wives of Hindu men whose husbands have converted to take another wife. Sarla Mudgal case is not there because Muslims are marrying more than one wife or Muslims are divorcing their wife. The problem was within the Hindu community. You do not say anything about these Hindu men who are taking advantage of your law, who are converting just for the sake of marrying another, and you want a certificate of nationalism and a proof of loyalty to the country by the Muslim community. I think this damages the cause of uniform civil code. I have said it repeatedly